questions and answers for F1, H1B and green cards. Certainly. Here are the top 10 questions and answers for Indian F1 students. 1. Question: can I work while studying on an F1 visa? Answer: yes, you can work on campus up to 20 hours per week during the academic year and full-time during designated breaks. 2. Question: can I work off campus on an F1 visa? Answer: under certain circumstances, you may be eligible for off-campus employment through optional practical training or curricular practical training programs. These require prior authorization from your designated school official. 3. Question: can I extend my F1 visa? Answer: F1 visas are typically valid for the duration of your study program. If you need to extend your stay, you'll need to apply for an extension through your DSO and provide a valid reason for the extension. 4. Question: can I transfer to another school on an F1 visa? Answer: yes, you can transfer to another CEVP-certified school by obtaining an acceptance letter from the new school and notifying your current DSO. 5. Question: can I travel outside the U.S. while on an F1 visa? Answer: yes, you can travel outside the U.S. during your program of study, but you'll need to ensure that your F1 visa and relevant travel documents are valid for re-entry. 6. Question: can I work during my opt period? Answer: yes, during the opt period, you are allowed to work in a job directly related to your field of study. However, you must have the necessary authorization from USHS. 7. Question: can I apply for a green card while on an F1 visa? Answer: while it is possible to apply for a green card while on an F1 visa, it typically requires meeting specific eligibility criteria and going through the proper immigration processes. Consult with an immigration attorney for guidance. 8. Question: can I bring my dependents on an F1 visa? Answer: yes, you can bring your spouse and children as dependents on an F2 visa. They will need to apply for their own F2 visas. 9. Question: can I work remotely for an Indian company while on an F1 visa? Answer: generally, working remotely for an Indian company while on an F1 visa is not permitted. F1 visa holders are expected to work within the U.S. for authorized employers. 10. Question: can I change my status from F1 to H1B? Answer: yes, it is possible to change your status from F1 to H1B if you find an employer willing to sponsor your H1B visa. The employer would need to file the necessary petitions and meet the requirements set by USHS. Remember, it's important to consult with your designated school official or an immigration attorney for personalized guidance based on your specific situation. Certainly. Here are the top 10 questions for Indians on H1B visas. 1. Question: what is the H1B visa and who is eligible to apply? Answer: the H1B visa is a non-immigrant visa that allows U.S. employers to hire foreign workers in specialty occupations. Eligible individuals include those with a bachelor's degree or higher in a specialized field and a job offer from a U.S. employer. 2. Question: how long can I stay in the U.S. on an H1B visa? Answer: initially, H1B visas are granted for a period of up to 3 years, with the possibility of extending it for up to 6 years in total. 3. Question: can I change employers on an H1B visa? Answer: yes, you can change employers on an H1B visa. The new employer needs to file a new H1B petition on your behalf, and once approved, you can start working for the new employer. 4. Question: can my H1B visa be transferred to a new employer? Answer: yes, you can transfer your H1B visa to a new employer by having the new employer file a new H1B petition on your behalf. The transfer process typically involves submitting the necessary documents and obtaining approval from USCIS. 5. Question: Can my family accompany me on an H1B visa? Answer: Yes. Your spouse and unmarried children under 21 years old can accompany you to the U.S. on an H4 visa. They may be eligible for certain benefits, but generally cannot work unless they obtain their own employment authorization. 6. Question: Can I apply for a green card while on an H1B visa? Answer: Yes. You can apply for a green card while on an H1B visa. The process typically involves your employer sponsoring your green card application through an employment-based immigration category. 7. Question: Can I travel outside the U.S. while on an H1B visa? Answer: Yes. You can travel outside the U.S. while on an H1B visa, provided you have a valid H1B visa stamp in your passport and all the necessary travel documents. However, it's important to consult your employer and immigration attorney for specific guidance. 8. Question: Can I work for multiple employers on an H1B visa? Answer: Yes. You can work for multiple employers on an H1B visa, but each employer must file a separate H1B petition on your behalf. And you must ensure that you maintain the terms and conditions of each employment. 9. Question: What happens if my H1B visa is not selected in the lottery? Answer: If your H1B visa is not selected in the lottery, you may explore alternative visa options such as the L1 visa, O1 visa, or other employment-based visas, depending on your qualifications and eligibility. 10. Question: Can I start my own business on an H1B visa? Answer: While it is possible to start your own business on an H1B visa, there are certain limitations and requirements. You may need to demonstrate that the business is operating as a legitimate employer-employee relationship and that you have the necessary qualifications and expertise. Please note that immigration laws and policies can change, so it's important to consult with an immigration attorney or professional for personalized advice based on your specific situation. Certainly. Here are the top 10 questions for Indians regarding green cards. 1. Question: What is a green card? Answer: A green card, also known as a permanent resident card, grants an individual lawful permanent residency in the United States, allowing them to live and work permanently in the country. 2. Question: How can I obtain a green card? Answer: There are various pathways to obtaining a green card, including employment-based sponsorship, family sponsorship, diversity visa lottery, refugee or asylum status, and more. The specific pathway depends on your individual circumstances. 3. Question: How long does it take to get a green card? Answer: The processing time for a green card can vary depending on the category, country of chargeability, and other factors. It can range from several months to several years. 4. Question: Can I apply for a green card through employment? Answer: Yes. Employment-based green cards are available for individuals who have a job offer from a U.S. employer who is willing to sponsor their permanent residency. The process typically involves labor certification and filing an immigrant petition. 5. Question: Can I apply for a green card through family sponsorship? Answer: Yes. If you have a close family member who is a U.S. citizen or a lawful permanent resident, they may be able to sponsor your green card application based on their relationship to you. 6. Question: Are there any special green card categories for Indians? Answer: There are no specific green card categories exclusively for Indians. However, India has a high demand for green cards, particularly in the employment-based categories, which may result in longer waiting times. 7. Question: Can I apply for a green card while on a non-immigrant visa? Answer: Yes, it is possible to apply for a green card while on a non-immigrant visa, such as an H1B or L1 visa. The process typically involves a change of status or adjustment of status application. 8. Question: what is the Diversity Visa Lottery Program? Answer: the Diversity Visa Lottery Program, also known as the Green Card Lottery, provides an opportunity for individuals from countries with low immigration rates to the U.S. to apply for a green card through a random selection process. 9. Question: are there any numerical limitations or quotas for green cards? Answer: yes. There are numerical limitations on the number of green cards issued each year, which vary depending on the category and country of chargeability. This can result in waiting times for certain categories, including those with high demand, such as employment-based green cards for Indians. 10. Question: can I travel outside the U.S. while my green card application is pending? Answer: traveling outside the U.S. while your green card application is pending can have implications. It is advisable to consult with an immigration attorney before making any travel plans to ensure that you have the necessary travel documents and understand the potential impact on your application. It's important to note that the green card process can be complex, and each individual's situation is unique. It is recommended to consult with an immigration attorney or qualified professional to get personalized guidance based on your specific circumstances. Question: what is the process of changing from an H1B visa to another company? What steps should I take if my current company becomes aware of my intention to switch? Answer: to change employers on an H1B visa, you should file for an H1B transfer before your current company takes any action. Once the transfer is filed, your current company cannot take any retaliatory measures. The process involves finding another employer who is willing to sponsor your H1B transfer. Question: I've never changed companies before, so I'm a bit confused.
I've never changed companies before, so I'm a bit confused. I currently have an H1B visa with Company A, but I'm interviewing with Company B. Will Company B need to take over my H1B visa? Answer: no, Company B does not need to take over your H1B visa. Instead, they can file a new H1B transfer for you, which will replace your existing H1B with Company A. There is no involvement required from Company A in this process. Question: what are the risks involved if something goes wrong with the H1B transfer? Answer: generally, the risk is low if you meet the necessary degree and job requirements. However, for extra security, it is advisable to wait for the H1B transfer to be approved before joining the new company. This helps minimize any potential complications or uncertainties. Question: can I start working for the new company as soon as the H1B transfer is received by USCIS? Answer: yes, you can start working for the new company as soon as the H1B transfer is received by USCIS. This is possible due to the concept of H1B portability, which allows you to begin employment with a new employer once the transfer has been received. Question: when should I inform Company A that I'm leaving? Answer: you should inform your manager at Company A and officially resign once the new H1B transfer has been filed. It is not necessary to wait for the transfer to be approved before resigning. Question: what should I do if the new H1B transfer gets denied? Answer: if the new H1B transfer gets denied, it can create difficulties. However, if your old company, Company A, keeps your old H1B active, it may help alleviate the problem. It is generally recommended to wait for the approval of the new H1B transfer before joining the new company to avoid complications. Question: is USCIS actively reviewing H1Bs based on notices of intent to revoke NOIRs? If I receive a notice of intent to revoke NOIR on my first H1B, should I return to India? Answer: yes, USCIS is actively reviewing H1Bs based on notices of intent to revoke NOIRs. If you receive a notice of intent to revoke on your first H1B, it is advisable to consult with an immigration attorney to understand your options. While returning to India may be one possible course of action, it ultimately depends on the specific circumstances of your case. It's important to seek legal advice to make an informed decision. Regarding the answer you provided, it seems to suggest filing for a B1/B2 visa to stay legally, but it's important to note that filing for a different visa category may not be the appropriate solution if your H1B is under scrutiny. It's crucial to consult with an immigration attorney to explore the best course of action based on your individual circumstances. Additionally, the statement about leaving before 180 days from the revocation date may not be accurate without considering the specific details of your case. Question: can I do an H1B transfer without pay slips if I have bank statements and W-2? Answer: yes, it is possible to do an H1B transfer without pay slips. Instead of pay slips, you can provide alternative proof of being paid, such as bank statements and W-2 forms. Question: what are the immigration advantages of a university job compared to a private company for permanent residence? Answer: the immigration advantages of a university job versus a private company for permanent residence depend on factors such as your country of birth and the employer's experience with the immigration process. For example, if you were born in India, an employment-based immigrant visa category called EB1 may offer advantages for university jobs. It's important to consult with an immigration attorney to understand the specific advantages and options based on your circumstances. Question: is it common or risky to have an H1B transfer with a visa stamp but no travel to the U.S.? Answer: it is relatively common to have an H1B transfer with a visa stamp but no immediate travel to the U.S. However, there may be some associated risks depending on the quota status and other factors. It's advisable to consult with an immigration attorney to understand the specific risks and implications in your situation. Question: USCIS has stated that they are reviewing H1Bs, but it has been over 2 months. Should I be concerned? Answer: it is unclear whether there is cause for concern if the review process for your H1B has taken over 2 months. However, in most cases, unless USCIS actually revokes your H1B, it is likely that everything is proceeding as normal. It is recommended to stay updated with any communications from USCIS and consult with an immigration attorney if you have specific concerns. Question: will there be a second H1B lottery this year? Answer: there is a good chance of a second H1B lottery being conducted this year, considering the high number of applications received. However, the final decision and announcement regarding a second lottery would be made by USCIS. It's important to stay updated with official announcements and consult with an immigration attorney for the most accurate information. Question: can I work remotely for an Indian company while in the US on an H1B visa? Answer: no, working remotely for an Indian company while on an H1B visa in the US is not allowed. H1B visa regulations require you to work at the employer's designated location in the United States. Question: are there any updates on H4 work authorization? Answer: as of the last 6 months, there have been no significant changes or updates regarding H4 work authorization. It's advisable to stay updated with official announcements from USCIS and consult with an immigration attorney for the latest information. Question: can I travel outside the U.S. while my STEM OPT extension is pending? Answer: the rules regarding travel while the STEM OPT extension is pending can be complex and depend on various factors. It is recommended to check the detailed travel rules provided in a blog post on immigration. Or consult with your designated school official DSO for specific guidance based on your situation. Question: how does H1B visa fraud happen, and what are the consequences? Answer: H1B visa fraud can occur when individuals apply for multiple H1Bs without a genuine job offer or engage in other fraudulent activities during the application process. The consequences of H1B visa fraud can be severe. Companies involved in fraudulent practices may face criminal penalties, and individuals can face visa revocation, ineligibility for future immigration benefits, or even criminal conspiracy charges. It is crucial to abide by the rules and regulations to maintain the integrity of the immigration system. Question: what is the outlook for obtaining H-1B visas given the high demand? Answer: obtaining H-1B visas through the lottery system has become highly competitive due to the high demand. To increase your chances, it is recommended to explore quota-exempt job opportunities such as those offered by universities, nonprofit organizations, or research institutions. However, the probability of success in the lottery remains uncertain due to the high number of applications received. It's advisable to consult with an immigration attorney for personalized advice based on your circumstances. Question: can I work remotely on an H-1B visa? Answer: generally, working remotely on an H-1B visa is not permitted. H-1B visas require you to work at the employer's designated location as mentioned in the petition. However, there are some exceptions and specific circumstances that may allow remote work. It's important to consult with an immigration attorney to understand if your situation qualifies for such exceptions. Question: what is the process and timeline for converting from OPT to H4 and H4 EAD? Answer: the process and timeline for converting from OPT to H4 and obtaining an H4 EAD employment authorization document can vary. It typically involves filing the necessary forms and supporting documents with USCIS and waiting for processing and approval. The timeline can range from several months to potentially longer, depending on various factors. It is advisable to file early and consult with an immigration attorney to ensure a smooth transition and avoid any gaps in work authorization. Question: I have an approved I-140. Can I get H-1B extensions beyond the 6-year limit? Answer: yes, if you have an approved I-140 petition, you may be eligible for H-1B extensions beyond the 6-year limit. The American Competitiveness in the 21st Century Act AC-21 allows for H-1B extensions in certain situations, such as when an individual's permanent residence green card process is ongoing. It's important to consult with an immigration attorney to understand the specific requirements and procedures for extending your H-1B beyond the 6-year limit. Question: what are the rules regarding the 60-day grace period for unemployment on H-1B? Answer: on an H-1B visa, you are generally allowed a 60-day grace period of unemployment between jobs. This grace period is intended to provide a reasonable period for individuals to find new employment without violating their H-1B status. It's important to note that the grace period is for each new period of unemployment and does not accumulate or continue from prior periods. Question: can I transfer H-1B employers while my application is still pending? Answer: yes, you can have multiple H-1B transfers pending concurrently as long as you maintain your H-1B status. However, it's important to ensure that the new employer's H-1B petition is properly filed and meets the requirements. It is advisable to consult with an immigration attorney to navigate the process correctly and maintain legal status. Question: what are some alternatives if I don't get selected in the H-1B lottery? Answer: if you do not get selected in the H-1B lottery, there are alternative visa options you can explore. These may include considering the L-1 visa for international transfers, the E-2 visa for treaty investors, or the O-1 visa for individuals with extraordinary ability. The suitability of each alternative will depend on your specific circumstances and qualifications. Consulting with an immigration attorney is recommended to explore the best alternative based on your situation. Question: can I travel outside the U.S. while my H-1B is being filed? Answer: yes, you can generally travel outside the U.S. while your H-1B petition is being filed. However, it's important to have the necessary documentation, such as an endorsed I-20 for F1 students or other relevant travel documents, to re-enter the U.S. without any issues. It's advisable to consult with your designated school official or an immigration attorney to ensure compliance with the travel rules and requirements. Question: When should I renew my Indian passport relative to H1B filing? Answer. You can renew your Indian passport at any time. However, it is important to provide accurate and up-to-date passport information when filing your H1B petition to avoid any discrepancies. It's advisable to consult with an immigration attorney to ensure you have the correct information and documentation for your H1B filing. Question. What are the backup options if my H1B doesn't get selected? Answer. If your H1B petition is not selected in the lottery, there are alternative options you can consider based on your situation. These may include options like continuing your studies with CPT, curricular practical training, exploring direct green card filing, considering other visa categories such as the O1 or L1 visas, or discussing potential options with an immigration attorney. The most suitable backup options will depend on your circumstances and long-term goals. Question. What is the minimum H-1B salary requirement? Answer. The minimum H-1B salary requirement is determined by the prevailing wage for the specific job and location. To determine the prevailing wage, you can check the FLC Data Center.com website or consult with an immigration attorney who can provide guidance based on your job and location details. Question. Can I work remotely for a U.S. employer from California on a TN visa? Answer. Yes, working remotely for a U.S. employer from California while on a TN visa is generally allowed. The TN visa, which is a non-immigrant visa for professionals under the NAFTA agreement, allows individuals from Canada and Mexico to work in specific professional occupations in the U.S. However, it's essential to ensure that your remote work arrangement complies with the specific requirements of the TN visa category. Question. If I have 2 degrees, can I get an H-1B in either field? Answer. Yes, if you have 2 degrees that both qualify for a specialty occupation, you can potentially get an H-1B visa in either field. The H-1B visa requires the job to be in a specialty occupation that typically requires a minimum of a bachelor's degree or higher in a specific field. As long as both of your degrees meet the criteria for a specialty occupation, you may be eligible for an H-1B visa in either field. Question. Can I start a business on OPT and what if it fails? Answer. While it is possible to start a business on OPT, optional practical training, there are certain regulations and restrictions to consider. It is essential to ensure that the business complies with all applicable laws and regulations, and that the primary purpose of your stay in the U.S. remains for practical training in your field of study. If the business fails, it can impact your immigration status, and you may need to explore alternative options such as finding new employment, returning to school, or changing your visa status. Consulting with an immigration attorney is recommended for guidance specific to your situation. Question. How are H-1B transfers handled if both petitions are selected in the lottery? Answer. If both H-1B transfer petitions are selected in the lottery, you have the option to choose which employer you want to join. You can proceed with one employer and the other employer will need to withdraw their petition. It's important to communicate your decision to both employers and coordinate the necessary steps to proceed with the chosen employer's H-1B transfer. Question. Does an undergraduate degree in analytics qualify for STEM? Answer. Whether an undergraduate degree in analytics qualifies for STEM, science, technology, engineering, and mathematics depends on the specific program curriculum and its alignment with the designated STEM fields. It is best to check with your designated school official DSO to determine if your analytics degree qualifies for STEM benefits, such as the STEM OPT extension. Types of opt. There are 3 types of opt. A. Pre-completion opt. This allows you to work part-time or full-time before completing your degree. During the academic year, you can work up to 20 hours per week. During official school breaks, you can work full-time. B. Post-completion opt. This is available after completing your degree. You can work full-time during this period. C. STEM opt extension. If you qualify for the STEM opt extension, you can work an additional 24 months after completing your degree. You must work for an employer enrolled in E-Verify and have a qualifying STEM degree. Reporting requirements. While on opt, you are required to report any changes in employment, address, or contact information to your DSO within 10 days. You must also submit an annual self-evaluation and validation report if you have a STEM opt extension. Travel. If you plan to travel outside the U.S. while on opt, you will need to carry your valid passport, valid F1 visa, EAD card, and an endorsed I-20 with a valid travel signature from your DSO. It's important to check travel regulations and consult your DSO before making any travel plans. It's important to note that opt is temporary employment authorization and is subject to certain restrictions and regulations. It's advisable to familiarize yourself with the specific rules and requirements related to opt and consult your DSO for guidance throughout the process. 16. Can I work while waiting for an H1B visa approval? While waiting for an H1B visa approval, you may wonder if you can work in the United States. Here are some important considerations. 1. H1B visa application status. First, it's essential to understand the status of your H1B visa application. If you have applied for an H1B visa transfer or a change of employer, you can continue working for your current employer until the U.S. CIS makes a decision on your case. However, if you have applied for an initial H1B visa or a change of status from another visa category, you may not be able to work until the H1B petition is approved. 2. H1B portability. The concept of H1B portability allows certain H1B visa holders to start working for a new employer once the U.S. CIS receives the H1B transfer petition. If you meet the criteria for H1B portability, you can begin working for the new employer even before the transfer is officially approved. 3. Unlawful employment. It's crucial to avoid any unauthorized employment that may violate the terms of your visa status. Working without proper authorization can have serious consequences, including visa revocation, deportation, and future immigration complications. It's important to follow the rules and regulations governing your specific visa category. 4. Employment Authorization Document, EAD. In some cases, individuals may have an Employment Authorization Document, EAD, that allows them to work in the U.S. independent of their H-1B status. If you have an EAD, you can continue working based on its validity, even if your H-1B visa application is still pending. 5. Consult an immigration attorney. To ensure compliance with immigration regulations and understand your specific situation, it's highly recommended to consult with an experienced immigration attorney. They can provide guidance based on the details of your case, advise you on the appropriate course of action, and help you navigate the complexities of U.S. immigration law. Remember, the information provided here is general in nature and may not apply to every individual's circumstances. It's always best to seek personalized legal advice to make informed decisions regarding your employment status while waiting for an H-1B visa approval. 17. How can I change employers on an H-1B visa? If you're currently on an H-1B visa and considering changing employers, here's an overview of the process. 1. Find a new employer. Begin by searching for a new employer who is willing to sponsor your H-1B visa. Look for job opportunities that match your skills and qualifications. 2. Job offer and employment agreement. Once you find a suitable employer, they will extend a job offer to you. Ensure that the offer letter includes details such as job title, responsibilities, compensation, and start date. It's also important to review and sign an employment agreement that outlines the terms and conditions of your employment. 3. H-1B transfer process. The H-1B transfer process involves filing a new H-1B petition with the U.S. CIS by your prospective employer. The new employer will need to submit the required forms, supporting documents, and filing fees. The petition should demonstrate that the position qualifies as a specialty occupation and that you meet the necessary qualifications. 4. H-1B transfer approval. After the H-1B transfer petition is filed, U.S. CIS will review the application. Once approved, you can legally work for the new employer. It's important to note that your employment authorization with the current employer remains valid until the H-1B transfer is approved. 5. Notify current employer. It's advisable to inform your current employer about your decision to change employers. However, you are not legally required to notify them before the H-1B transfer is filed or approved. Once the transfer is approved, your H-1B status will be automatically transferred to the new employer. 6. Resignation and transition. After the H-1B transfer is approved, you can resign from your current position and begin working for the new employer. It's recommended to maintain a professional approach during the transition and comply with any notice period or contractual obligations. It's important to consult an immigration attorney throughout the H-1B transfer process to ensure compliance with immigration laws and regulations. They can guide you through the documentation requirements, help you understand your rights and responsibilities, and address any specific concerns related to your case. Remember, each immigration case is unique, so personalized legal advice is essential for a smooth H-1B transfer process. 18. What happens if the H-1B transfer is denied? If your H-1B transfer petition is denied, it can create a challenging situation. Here's what you need to know. 1. Status with current employer. If your H-1B transfer is denied, your status remains tied to your current employer. As long as your current H-1B status is valid, you can continue working for them without interruption. 2. Options to explore. If your H-1B transfer is denied, you can consider the following options. A. Appeal or motion to reopen. If there are grounds to challenge the denial decision, you may have the option to file an appeal or a motion to reopen the case. Consulting with an immigration attorney is crucial in this situation to determine the best course of action. B. Seek employment with another employer. You can search for another employer who is willing to sponsor your H-1B visa and file a new H-1B petition on your behalf. This would require starting the H-1B application process from scratch. C. Explore other visa categories. Depending on your qualifications and circumstances, you may be eligible for alternative visa categories such as the O1 visa for individuals with extraordinary ability, the L1 visa for intracompany transferees, or the F1 visa for individuals with extraordinary ability or outstanding professors researchers. Each visa category has its own requirements, so consulting with an immigration attorney is recommended to explore the best option for you. 3. Departure from the United States. If you are unable to secure employment with another H-1B sponsor or explore alternative visa options, you may need to consider departing from the United States before your current H-1B status expires. Staying beyond your authorized period of stay could result in negative immigration consequences and potential future visa denials. It's important to consult with an immigration attorney if your H-1B transfer is denied. They can evaluate your case, provide guidance on available options, and help you navigate the complex immigration process. They will be able to assess the specific reasons for the denial and advise you on the best course of action based on your circumstances. Remember, immigration laws are complex and subject to change, so professional legal advice is crucial to protect your rights and explore the most appropriate options. 19. Can I appeal a denied H-1B petition? If your H-1B petition is denied, you may have the option to appeal the decision. Here's what you should know about the appeal process. 1. Understand the reason for denial. Before deciding to appeal, it's important to understand the specific reasons for the denial. U.S. C.I.S. typically provides a detailed explanation for the denial in the official notice. Review the notice carefully to identify the grounds on which your petition was denied. 2. Eligibility for appeal. Not all H-1B denials are eligible for appeal. U.S. C.I.S. allows appeals for certain types of petitions, such as H-1B petitions, but there are exceptions. For example, if your H-1B petition was denied due to a request for evidence (RFE) response that was not submitted on time or was deemed insufficient, you may not be eligible for an appeal. 3. Timely filing. If you decide to appeal, it is crucial to file the appeal within the specified timeframe. U.S. C.I.S. typically provides a deadline for filing the appeal in the denial notice. Failing to meet the deadline may result in the appeal being rejected. 4. Appeal process. The appeal process involves submitting Form I-290B, Notice of Appeal or Motion, along with the required supporting documentation and the appropriate filing fee. The appeal will be reviewed by the U.S. C.I.S. Administrative Appeals Office (AO), which is an independent body that conducts a thorough review of the case. 5. Consult with an immigration attorney. Appealing a denied H-1B petition can be complex and requires a strong legal strategy. Consulting with an experienced immigration attorney is highly recommended. They can evaluate your case, review the denial notice, and determine the best approach for your appeal. An attorney will help gather additional evidence, address any deficiencies in the original petition, and present a compelling argument to support your case. 6. Alternative options. While appealing is one option, it may be worth exploring alternative options simultaneously. This could include considering a new H-1B petition with a different employer, exploring other visa categories that may be suitable for your situation, or seeking legal advice on other possible avenues to pursue. It's important to note that the appeal process can be lengthy, and there is no guarantee of a favorable outcome. Working with an immigration attorney can greatly improve your chances of a successful appeal by ensuring that all necessary documentation is included and presenting a strong argument in your favor. 20. What are the consequences of overstaying an H-1B visa? Overstaying an H-1B visa can have serious consequences. Here are some important points to consider. 1. Unlawful presence. If you remain in the United States beyond the authorized period on your H-1B visa, you accrue unlawful presence. This can have severe implications for future immigration benefits and may lead to a bar on re-entry to the United States. 2. Visa revocation. If you overstay your H-1B visa, your visa may be revoked by the U.S. consulate or embassy. This can make it difficult to obtain future visas or re-enter the United States. 3. Immigration consequences. Overstaying on an H-1B visa can negatively impact your immigration status. It can result in a loss of legal status, making you subject to deportation or removal proceedings. 4. Ineligibility for adjustment of status. Overstaying can render you ineligible for adjusting your status to permanent residency (green card) within the United States. This can significantly hinder your path to obtaining permanent residency. 5. Future visa applications. Overstaying an H-1B visa can create complications when applying for other visas in the future. It can raise questions about your immigration history and intentions, making it more challenging to secure visas for work, study, or tourism purposes. 6. Bans and inadmissibility. If you accrue more than 180 days of unlawful presence and depart the United States, you may trigger a 3-year or 10-year ban from re-entering the country. These bans can significantly impact your ability to visit, study, work, or immigrate to the United States in the future. 7. Impact on employment. Overstaying an H-1B visa can result in termination by your employer, as they may be legally obligated to employ individuals with valid work authorization. It is crucial to maintain lawful immigration status and comply with the terms and conditions of your visa. If you anticipate any issues or need to extend your stay, it's essential to consult with an immigration attorney to explore available options and ensure compliance with U.S. immigration laws. They can provide guidance based on your specific circumstances and help you navigate the complexities of immigration processes. 21. Can I apply for a green card while on an H-1B visa? Yes, it is possible to apply for a green card while on an H-1B visa. Here are some key points to consider. 1. Employment-based green card. As an H-1B visa holder, you may be eligible for an employment-based green card. The green card process is typically employer-sponsored, and your employer would file an immigrant petition on your behalf. 2. Labor certification. For most employment-based green cards, including the commonly used EB2 and EB3 categories, your employer would need to obtain a labor certification from the U.S. Department of Labor (DOL). This certification verifies that there are no qualified U.S. workers available for the position being offered to you. 3. Immigrant petition. Once the labor certification is approved, your employer can file an immigrant petition, such as Form I-140, with U.S. Citizenship and Immigration Services (USCIS). This petition establishes your eligibility for the green card and is typically accompanied by supporting documentation. 4. Priority date. When the immigrant petition is filed, you are assigned a priority date. The priority date establishes your place in the queue for a green card, as the availability of green cards is subject to annual numerical limits in certain categories. 5. Adjustment of status or consular processing. Once the immigrant petition is approved, the next step depends on whether you are eligible to adjust your status within the United States or if you must undergo consular processing at a U.S. embassy or consulate abroad. Adjustment of status allows you to apply for a green card while remaining in the United States, while consular processing requires you to complete the process at a designated U.S. embassy or consulate in your home country. 6. Green card interview. As part of the process, you and, in some cases, your spouse, if applicable, may be required to attend an interview with USCIS. The purpose of the interview is to assess the validity of your application and eligibility for the green card. It's important to note that the green card application process can be complex and lengthy. The specific requirements and processing times can vary depending on the category of the green card, your individual circumstances, and any country-specific considerations. Consulting with an immigration attorney who specializes in employment-based immigration is highly recommended. They can guide you through the process, help you understand your options, and ensure that your application is properly prepared and submitted. 22. What is the process for obtaining a green card through marriage? Obtaining a green card through marriage to a U.S. citizen or lawful permanent resident (LPR) involves the following general steps. 1. Determine eligibility. The first step is to ensure that you meet the eligibility requirements. Generally, you must be legally married to a U.S. citizen or LPR, and the marriage must be bona fide, meaning it is based on a genuine and legitimate relationship. 2. File the immigrant petition. If you are married to a U.S. citizen, your spouse must file Form I-130, Petition for Alien Relative, on your behalf. If you are married to an LPR, your spouse must file Form I-130A, Supplemental Information for Spouse Beneficiary, along with the I-130. These forms establish the relationship and initiate the green card process. 3. Wait for petition approval. After filing the immigrant petition, you will need to wait for USCIS to review and approve it. Processing times can vary, but once approved, the petition will be forwarded to the National Visa Center (NVC) for further processing. 4. Prepare the application. At this stage, you will need to prepare the application for the green card itself. This involves completing Form I-485, Application to Register Permanent Residence or Adjust Status. Along with the form, you will need to submit supporting documentation, such as proof of identity, marriage certificate, medical examination results, and evidence of financial support, among others. 5. Attend biometrics appointment. After submitting the application, you will be scheduled for a biometrics appointment. During this appointment, your fingerprints, photograph, and signature will be collected for background checks. 6. Attend green card interview. USCIS may require you and your spouse to attend an interview. The purpose of the interview is to verify the authenticity of your marriage and assess your eligibility for the green card. Both you and your spouse will be questioned separately and may be asked to provide additional evidence to support your application. 7. Wait for decision. Following the interview, USCIS will make a decision on your green card application. If approved, you will be granted conditional permanent residence if the marriage is less than 2 years old at the time of approval. If the marriage is more than 2 years old, you will receive a permanent green card. 8. Removal of conditions if applicable. If you received conditional permanent residence, you will need to file a joint petition with your spouse to remove the conditions within the 90-day period before the expiration of your conditional green card. 9. Receive the green card. Once all requirements are met and the conditions are removed, you will receive your permanent green card, which grants you lawful permanent residence in the United States. The process of obtaining a green card through marriage can be complex, and the specific requirements and procedures may vary based on individual circumstances. It is crucial to consult with an immigration attorney to ensure that you understand the process, meet the eligibility criteria, and properly complete and submit all required forms and supporting documents. 23. Can I apply for a green card while on a student visa F1? Yes, it is possible to apply for a green card while on a student visa F1. However, the process and eligibility requirements for obtaining a green card can vary depending on your specific circumstances and the available immigration pathways. Here are a few potential options for applying for a green card while on an F1 student visa. 1. Employment-based green card. If you have a job offer from a U.S. employer who is willing to sponsor your green card, you may be eligible to apply for an employment-based green card. There are several employment-based categories, such as EB1 for individuals with extraordinary ability, EB2 for professionals with advanced degrees or exceptional ability, and EB3 for skilled workers, professionals, and other workers. The process typically involves your employer filing a petition on your behalf, and you may need to go through the labor certification process. 2. Family-based green card. If you have a close family member who is a U.S. citizen or lawful permanent resident, they may be able to sponsor your green card through a family-based category. Immediate relatives of U.S. citizens, such as spouses, parents, and unmarried children under 21, have higher priority and may have faster processing times. Other family members, such as married children of U.S. citizens or siblings, fall into different preference categories and may have longer wait times. 3. Diversity Visa Lottery. The Diversity Visa Lottery, also known as the Green Card Lottery, is a program that allows individuals from certain countries with historically low rates of immigration to the United States to apply for a green card. Each year, a limited number of diversity visas are available, and applicants are selected through a random lottery system. If you are selected, you can apply for a green card and adjust your status while on an F1 visa. 4. Special immigrant categories. There are various special immigrant categories that may offer a pathway to a green card. For example, individuals who have worked for the U.S. government, religious workers, certain foreign medical graduates, and others may qualify under specific categories. Each category has its own eligibility criteria and requirements, so it is important to determine if you meet the qualifications. It is crucial to note that the green card application process can be complex, and it is highly recommended to consult with an immigration attorney to assess your eligibility, determine the most appropriate pathway for your situation, and navigate the application process successfully. The attorney can guide you through the specific requirements, forms, supporting documentation, and any potential challenges or issues that may arise during the process. 24. Can I travel internationally while my H1B change of status is pending? Yes, it is possible to travel internationally while your H1B change of status is pending, but there are important considerations to keep in mind. The ability to travel depends on the stage of your change of status application and whether you have obtained certain documents. If you have filed an H1B change of status application and it is still pending with the United States Citizenship and Immigration Services (USCIS), you can travel internationally. However, there are some potential risks and requirements. 1. Valid travel documents. Ensure that you have a valid passport and visa to re-enter the United States. If you are on an F1 student visa and have a pending H1B change of status, you may need to have your F1 visa stamp and an endorsed Form I-20 from your designated school official DSO to re-enter the U.S. 2. Advance parole. If you have also filed an application for an Employment Authorization Document (EAD) or advance parole, commonly known as Form I-765, you can apply for an advance parole document. This document allows you to travel internationally and return to the U.S. while your H-1B change of status is pending. It is important to have the approved advance parole document before traveling to avoid complications at the port of entry. 3. Risks and delays. Traveling internationally while your change of status is pending carries some risks. There is a chance that your H1B application could be denied while you are outside the US, which may result in the abandonment of your change of status request. Additionally, delays or complications during travel could impact your ability to return to the US in a timely manner. 4. Consular processing. Alternatively, if you have filed your H1B petition along with a request for consular processing instead of a change of status, traveling internationally is generally permissible. In this case, you would need to attend an interview at a U.S. embassy or consulate abroad to obtain an H-1B visa stamp before returning to the U.S. to work for your new employer. It is crucial to consult with an immigration attorney or an experienced immigration professional before making any international travel plans while your H-1B change of status is pending. They can provide personalized guidance based on your specific circumstances and ensure that you have the necessary documents and understand the potential risks involved. 25. My student visa got rejected previously due to fraud. Will this impact my H-1B visa application? Yes, if your student visa application was previously rejected due to fraud, it can potentially impact your H-1B visa application. Visa fraud is a serious offense and can have long-term consequences on your immigration record. When you apply for any visa, including the H-1B visa, the U.S. Department of State and the U.S. Citizenship and Immigration Services (USCIS) conduct background checks and review your immigration history. Any instances of past visa fraud or misrepresentation can raise concerns and may result in a denial or heightened scrutiny of your H-1B visa application. It is important to note that immigration authorities share information and maintain records of visa applicants, including instances of fraud or misrepresentation. When you apply for a new visa, your previous visa applications and any associated issues may be taken into consideration. If your student visa application was rejected due to fraud, it is advisable to consult with an experienced immigration attorney who can assess your situation and provide guidance on the best course of action. They can help you understand the potential impact of the previous rejection on your H-1B visa application and assist you in presenting a strong and credible case to address any concerns raised by the immigration authorities. In some cases, it may be necessary to apply for a waiver to overcome the impact of a previous visa rejection due to fraud. A waiver is a discretionary remedy that allows individuals who would otherwise be inadmissible to enter or remain in the United States. The availability and requirements for a waiver vary depending on the circumstances of the case and the specific visa category. Ultimately, it is crucial to be honest and transparent throughout the visa application process. Any attempt to conceal or misrepresent information can have severe consequences and may negatively impact your immigration prospects. Working with an immigration attorney can help ensure that you navigate the process correctly and increase your chances of a successful H-1B visa application. 26. When can I enter the U.S. on a new F1 visa for fall? You can enter the United States on a new F1 visa for the fall semester typically within 30 days before the program start date mentioned on your I-20 form. The exact timing may vary depending on the specific policies of the U.S. Embassy or consulate where you will be applying for the visa. It's important to plan your travel accordingly and make sure you have all the necessary documentation ready before your departure. Here are a few key points to keep in mind. 1. Program start date. The program start date is indicated on your I-20 form, which is issued by your educational institution. It's crucial to arrive in the U.S. no later than the program start date mentioned on your I-20. 2. Visa application process. Before you can enter the U.S., you need to apply for an F1 visa at a U.S. embassy or consulate in your home country. The visa application process typically involves completing an application form, paying the required fees, attending an interview, and providing supporting documents. It's recommended to check the specific requirements and processing times of the embassy or consulate where you will be applying. 3. Visa processing time. The time it takes to process an F1 visa application can vary depending on the embassy or consulate and other factors. It's advisable to apply for your visa well in advance to allow for any potential delays. Check the website of the U.S. Embassy or Consulate for information on current visa processing times. 4. Travel arrangements. Once you have received your F1 visa, you can make travel arrangements to the U.S. It's generally recommended to book your flight to arrive at least a few days before the program start date to allow for any unforeseen circumstances or jet lag. 5. Port of entry. When you arrive in the U.S., you will go through immigration and customs at the port of entry. Make sure to have all your required documents easily accessible, including your passport, F1 visa, I-20 form, and any other supporting documents requested by the immigration officer. It's always a good idea to stay informed about any travel restrictions, entry requirements, and COVID-19 related guidelines that may be in place at the time of your travel. You can check the website of the U.S. Department of State and the U.S. Customs and Border Protection for the most up-to-date information. Remember to consult with your designated school official DSO for any specific instructions or recommendations regarding your arrival and orientation at your educational institution. They will be able to provide guidance tailored to your specific circumstances and help ensure a smooth transition to your studies in the U.S. Certainly. Here's the continuation. Question: do I need to quarantine when I arrive in the U.S.? Answer: the quarantine requirements upon arrival in the U.S. can vary depending on the current guidelines and regulations set by the Centers for Disease Control and Prevention (CDC) and the Customs and Border Protection (CBP). It's important to stay updated on the latest travel advisories and guidelines related to COVID-19. As of now, fully vaccinated individuals may not be required to quarantine, but it's advisable to check the specific requirements for your destination state or city. Keep in mind that the situation can change, so it's always best to review the most recent guidelines before you travel. Question: what's the difference between a green card and citizenship? Answer: a green card, also known as a permanent resident card, grants the holder lawful permanent residence in the United States. It allows individuals to live and work permanently in the country. Green card holders have many of the same rights and benefits as U.S. citizens, such as access to employment opportunities, Social Security benefits, and the ability to sponsor certain family members for immigration benefits. However, green card holders are not U.S. citizens and do not have the right to vote in federal elections or hold certain government positions. On the other hand, citizenship, also known as naturalization, is the process of becoming a legal citizen of the United States. U.S. citizens have all the rights and privileges granted by the U.S. Constitution, including the right to vote, travel with a U.S. passport, and hold any job without restriction. Citizenship also provides protection from deportation and allows individuals to petition for a wider range of family members to immigrate to the U.S. Additionally, U.S. citizens are eligible for certain government benefits and can participate fully in the democratic process of the country. While green card holders have permanent residency status, citizenship offers the highest level of legal status and provides additional benefits and opportunities. However, obtaining citizenship requires meeting specific eligibility criteria, including residency requirements, knowledge of English and U.S. civics, and passing a naturalization exam and interview. It's important to consult with an immigration attorney or refer to the official U.S. Citizenship and Immigration Services (USCIS) website for detailed information about the naturalization process and requirements. If you have any further questions or need additional information, please let me know.